Testing 1 2 3. Testing 1 2 3.
Yeah, that's probably a really good idea. Exactly. Perfect. Okay.
Testing 123.
Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Petitioner, if you're ready, I think we're ready to hear from you. Thank you. Have you already reserved any time for rebuttal?
Not yet, Your Honor. May we reserve 2 minutes for rebuttal?
You may.
Thank you, Your Honor. Good evening, Madam Chief Justice, and may it please the court, my name is Thomas Fletcher, and I represent cross-respondent Dr. Henry Draken. My co-counsel, Kelsey McLean, also represents Dr. Draken, as well as the Securities and Exchange Commission. A person who promotes a United States security on a United States social media platform to an audience she's cultivated in the United States may fairly be hailed into a United States court. We urge this court to affirm the 14th Circuit's decision to exercise personal jurisdiction over Ms. Possible and reverse its decisions on the securities issues. Co-counsel will argue that Dr. Draken and the SEC have alleged sufficient facts to state claims under the Securities Act. And I will argue that Ms. Possible is subject to personal jurisdiction in the United States for 2 reasons. First, an actor establishes minimum contacts with the United States when she targets the United States with a promotional social media post. Second, it is fair and just to exercise personal jurisdiction over such an actor. Personal jurisdiction is all about fairness. This court developed the minimum contacts test in 1945 in International Shoe Company versus Washington. Minimum contacts exist where 1, a defendant's contacts with the forum relate to the plaintiff's cause of action. 2, the defendant has purposefully availed herself of the forum. And 3, the defendant's contacts are such that she should reasonably anticipate being hailed into a forum court.
Can you address why that is? These contacts seem pretty minimal to me, I have to tell you. She seems mostly focused in her hometown in Middleton, which I don't believe is in the U.S.
Your Honor, that's true. She is focused on Newland, but Ms. Possible has all 3 minimum contacts with the United States, and further, it is fair and just to exercise jurisdiction over her. Ms. Possible has 3 contacts at issue here with the United States. First, as noted on page 3 of the record, Ms. Possible has traveled to the United States once or twice a year to cultivate an audience and build her following. Second,
But what counsel, does that travel have anything to do with the allegations in this matter involving a securities violation?
it does, Your Honor, because while she was doing that, she was building her brand, which is her influence, and she later targeted her followers. She has followers in every state in the United States, also on page 3 of the record, with the Y post that caused injury in the United States.
Well, if her post was advertising, let's say, clothes she was going to be wearing during the match, is it just enough that an influencer puts up a post that people in the US will read? What has to be the connection between the post and the case?
That would not be enough, Your Honor, because that would only be available in the United States. Purposeful availment is necessary, and that happens when an actor targets the United States with a post. A post may be targeted when it fits either of 2 categories. The first is when it's reasonably calculated to reach investors within the forum. The second is when it causes a substantial effect in the forum. Ms. Possible has done both. Turning first to the reasonable calculation, that language comes from an 11th Circuit case. In SEC versus Carrillo, a Costa Rican defendant placed securities advertisements in American Airlines in-flight magazines. The court in Florida decided to exercise personal jurisdiction over that foreign defendant based not on the fact that those advertisements would certainly reach American investors, not on the fact that they would only reach American investors, but because it was reasonably calculated through the defendant's purposeful actions that those advertisements would reach an American audience.
But counsel, a social media post seems to me different than placing something specifically in a magazine that you know will reach a specific audience, because a social media post could reach anyone anywhere in the world, right? Shouldn't we be concerned about the fairness implications of what you're proposing?
Certainly, Your Honor. Fairness is the constitutional touchstone of the minimum contacts test. But where here, Ms. Possible took affirmative actions to build a following in the United States, she was more than aware that it would reach the United States. It is not petitioner's position that Ms. Possible has targeted every forum in the world. However, the United States, where she was coming to participate in the cage match at the Four Corners Monument, shows targeting of the United States. Page 12 of the record indicates a map of that cage match, 75% of which is in the United States and was part of the overall promotion of the security that led to Dr. Draken's harm.
Now, is there, I thought I saw evidence in the record that the post was placed outside of the U.S. in Newland. If that's correct, how, if at all, does that affect the analysis?
It doesn't, Your Honor. This court has stepped away from the idea that physical presence is necessary to avail oneself of a forum. That speaks to the second way in which Ms. Possible targeted the United States, and that's the substantial effect that her post had here. This court adopted an effects test in Calder versus Jones. There, a Florida defendant published 600,000 copies of a libelous magazine article in California. Like Ms. Possible, he had not traveled to the forum, he had not gone to California. However, this court upheld personal jurisdiction as fair and decided that because California was the focal point of the harm and the damage in that case, it was fair for that defendant to travel to California to defend.
Counsel, I'm trying to understand your argument and think about how it would work in a different case. Do you have to establish how many people in the United States viewed this post? Is it the viewer, or is it the marketing that's intended? Is it a subjective, objective test? Which is it?
It's objective, Your Honor, and that's what the 11th Circuit decided in the Carrillo case. And here, if this court decided that the number of American followers Ms. Possible had were important, this case should be remanded for discovery. We are at the motion to dismiss stage, and Dr. Draken has pled sufficient facts to state a prima facie case of personal jurisdiction.
But he doesn't, I'm sorry, Your Honor, but he doesn't allege that he even saw this post, right?
That's correct, Your Honor, and that speaks to the relatedness element, the first element of minimum contacts. Reliance and but-for causation are not prerequisites to relatedness. This court made that distinction in 2021 in Ford Motor Company versus Montana, 8th District Court. There, plaintiffs sued Ford in the state of Montana based on vehicle defects. However, they had not purchased their Ford vehicles in Montana. They had bought them secondhand outside the state. But this court held that when a defendant has advertised in a forum and that the product they're advertising has caused injury in the forum, that forum may entertain resulting suits.
But the volume of business that Ford Motor Company does in a state like Montana dwarfs, by comparison, the limited contact that she had by sending out this one social media post, not really related to her overall efforts to build her brand.
It's true that Ford has far more substantial contact with every bit of the United States than Miss Possible. However, her contract with Octocoin involves purposeful availment towards the United States as a whole and shows relatedness between the fact that she was promoting a fraudulent security and that very fraudulent security injured a United States resident, Dr. Draken.
So what is the closest case in terms of the context we have here? It looks to me, maybe there's something else in the record I'm missing, but that you have the post, you have the fact that the match is on the border. Is there anything else?
The third contact is on page 3, and it's Miss Possible's annual or twice-a-year travels to the United States where she built that following.
Okay, so what is the case that's closest for you with contacts that, as my colleagues suggested, are perhaps not as robust as what we've seen in some other cases?
This is a case of first impression, and it's difficult to compare Miss Possible's contacts to others that have been handled, but the closest is that 11th Circuit case, SEC versus Carrillo, where a foreign defendant had not physically entered, but advertised and led to jurisdiction. And secondly, the Calder case, in which physical presence was not a requisite for purposeful availment.
So how do we think about the agreement, given that Ms. Possible did not sign that agreement? I believe it was signed by her mother. But are you relying on the agreement with Octocoin to support your claim for personal jurisdiction?
The agreement, Your Honor, speaks to the fairness involved, and Miss Possible was 17 when she contracted with Octocoin through her mother. However, when she became the age of majority, she did not void that contract, and she did fulfill all the material terms of that contract. This court, after establishing minimum contacts, looks to the substantial fairness and traditional notions of fair play. This court noted in Asahi Metal Industries versus California Superior Court that it is rare that a defendant with minimum contacts with the forum would be unfairly hailed into a forum. This court...
Sorry, I just wanted to ask, is it the SEC's position that it could take an enforcement action against anyone with the level of contacts that we have here?
Your Honor, the SEC's jurisdiction has not been challenged in this case. Dr. Draken's has. And the SEC, when acting under the Security Act, because it authorizes worldwide service, does have that option. And the record indicates on page 19 at footnote 10 and page 31 that all circuits that have addressed that issue are in favor. This court noted in Burger King versus Rudziewicz that overcoming minimum contacts and showing that jurisdiction would be unfair takes a significant showing. The 11th Circuit in Vermeulen versus Renault looks to 3 factors that are at issue here. First, the burden on the defendant in litigating in the forum. Second, the plaintiff's interest in litigating in that forum. And third, the forum's interest. Ms. Possible's burden will be de minimis in this case, as she need only make the same trip she's made to promote her brand to defend herself in court.
Counsel, I'm sorry, but Your Honor, counsel, there's a big difference between traveling to a country to promote your brand once or twice a year and being hailed into court and litigating for what could be months of discovery, depositions, trial proceedings. I mean, that's a huge difference.
There is, Your Honor. But Ms. Possible has essentially conducted business in the United States when she made those trips to the United States. Octocoin only contracted with her because she has such a massive following, 15 million followers on the social media at issue. And she was conducting the business that gave rise to that when she was attending promotional events and building her brand in the United States.
Is there any distinction that we should draw from traveling across an international border versus a New York resident, for example, being hailed into court in California? Is there anything we should think about in that context, the difference between interstate travel as opposed to crossing national borders?
Certainly, Your Honor, it speaks to the fairness and the burden on the defendant. It is more burdensome to cross an international border rather than a state border. However, it is fair where that same defendant has crossed that border to conduct business, as is the case here. Ms. Poss.
Are you asking us to consider a different definition of minimum contacts when someone is conducting most of their business online? A lot of your argument is sort of, seems to me to be using very traditional approach about how often someone's actually got boots on the ground in a world in which they're not doing any business in boots on the ground. Should we just come up with a new test?
Absolutely not, Your Honor. The minimum contacts test was created to adapt with time, and it's done so. As new forms of transportation have made travel less burdensome, it's adapted. As people have begun conducting business over the internet, it's adapted. And this court should only hold that a social media influencer may remotely target a forum and be hailed into that forum based on advertisements. Thank you, Your Honors.
Thank you. We'll now hear from you, counsel. Thank you.
Good evening, Madam Chief Justice, and may it please the court. My name is Kelsey McLean, and I also represent Dr. Henry Draken, along with the Securities and Exchange Commission. The Securities Act provides a remedy when a social media influencer hurts people by failing to disclose that her promotion of a security is bought and it's paid for. We respectfully urge this court to reverse the 14th Circuit's decision to dismiss both claims under the Securities Act and apply the act to Ms. Possible's social media post for two reasons. First, a person qualifies as a seller under the act when she solicits the sale of a security through a mass communication on social media. And second, a person violates the anti-touting provision of the act when she fails to disclose the compensation she receives to post that particular promotion. Social media influencers have a dangerous level of control over the cryptocurrency market. When Elon Musk posted about Dogecoin, its value increased by 60%. When Kim Kardashian posted about Ethereum, its value increased by 82%. And when Ms. Possible posted about Octocoin, the value of her own interest increased by 100% in just 7 days.
Now, counsel, under Section 17, why isn't revealing the number of coins enough of a disclosure given the nature of those coins not having a fixed value at any given time? If she gave a value at any given time, then you may be up here arguing that, or at the trial court arguing that she gave a false statement that because the value was different.
Your Honor, the fact that cryptocurrencies are so volatile is why she needed to disclose the monetary value under Section 17 at subsection B. Because someone who looked at Ms. Possible's post days later may not understand what it took to buy her opinion. And what it took to buy Ms. Possible's opinion was $1 million, as indicated on page 5 of the record. The 11th Circuit in Wilds versus BitConnect noted the volatility of cryptocurrency.
But counsel, she got the value on the day of the match, right? But she posted her online solicitation, if you will, several days before the match, right?
Yes, Your Honor,
so there were
she did.
two different values. Which value should she have put down?
She needed to post the value of Octocoins at the time of her promotion, which was February 1st when she posted the post on page 6 of the record. She needed to make her followers aware of what it took to buy her opinion. The Section 17 at subsection B requires that a person who promotes a security fully disclose the compensation they receive and the amount thereof.
Counsel, I want to talk for a minute about the statutory seller question. I'll be honest, it seems to me like this is a real expansion in the SEC's jurisdiction here. If you can, as I take it, you are telling us that you can, and if not, please correct me, but if you can bring an action against any social media influencer who posts something encouraging any of the millions and millions of folks that might look at it to do X, how is that not something that goes way beyond the scope of your enforcement authority that we've seen in the past?
The statutory seller requirement is for Dr. Draken's claim under Section 12 at subsection A2. And it requires that someone solicit the sale of a security. Dr. Draken isn't arguing that any social media influencer who promotes cryptocurrencies on the internet would be found liable under that section.
So I might have been confused. I thought the SEC also had an action, but is it only Dr. Draken?
They both have separate claims. Dr. Draken's claim arises under Section 12, where he alleges that Ms. Possible qualifies as a seller under that specific subsection.
But the SEC's position, I take it, is the same.
The SEC's position, or excuse me, the SEC brought a claim against Ms. Possible under Section 17B of the Act for just failing to fully disclose.
And that's something that their position is they could do with respect to any social media influencer. So what I'm wrestling with is it just seems to me that your theory broadens the scope of the SEC's power a lot, and maybe you can respond to that concern.
Your Honor, it doesn't broaden their power. It's just adapting what they do to the realities of this world. And in the internet age, people do conduct business over the internet, particularly with cryptocurrencies. The Federal Trade Commission issued a report just last year that indicated that Americans lost over $1 billion to cryptocurrency fraudulent schemes. And over half of that amount of money was directly attributable to social media influencers.
But where
Counsel,
in
turning-
her post, I mean, I'm not saying it's not a big social problem about cryptocurrency, but where in this post is she asking anyone to buy anything?
Your Honor, she's asking her followers to purchase Octocoin for 3 reasons. First, as you can see on page 6, she includes Octocoin's slogan, invest in yourself, which page 4 of the record indicates Octocoin uses to solicit the sale of their security. Second, she includes that link to www.getoctocoinnow.com, which page 6 indicates took her followers to a website where they could view a promotional video which informed them about how to purchase Octocoin. It gave them material information. And finally, Ms. Possible participated in an extensive promotional campaign in which she agreed to physically fight the CEO of Octocoin as part of this solicitation effort. Ms. Possible directly and actively participated in the solicitation.
So if someone copies a website link and posts it, is that enough for them to be a seller? Because a lot of people would be very surprised that they could be subject to SEC liability for sending someone to a website.
No, Your Honor, that alone wouldn't be enough. Under Pinter versus Dahl, this court actually established a 2-part test to determine when someone qualifies as a seller. First, they would need to solicit the sale of the security. And second, they would need to do so motivated at least in part by their own financial benefit or the financial benefit of the securities owner.
So how does your argument not collapse the distinction between advertising and soliciting? Like imagine if you had a billboard that had the slogans that you mentioned. Under your argument, wouldn't that be a solicitation?
Yes, Your Honor, it would, because it would urge people to purchase a cryptocurrency.
So you would agree that any advertisement that includes a company's slogans is a solicitation?
As long as that advertisement also gives material information about the cryptocurrency.
Okay, and so what is the material information that's provided in Ms. Possible's post?
It's that link to Octocoin's website where her followers could learn about how to invest so that they could invest immediately. That's why she directly and actively participated in the solicitation process here. The 14th Circuit reasoned that Ms. Possible would have needed to directly and actively target an individual purchaser, but the 11th Circuit in Wilds versus BitConnect noted that that would just create a loophole in the act. It would allow Ms. Possible to evade liability for a message that she would face liability for if she had sent it to one person, by merely posting it to 15 million people, as she did in this case, causing more widespread harm.
Counsel, do you think that this statute clearly advises people who are engaged in social media efforts that they might subject themselves to securities law violations if they don't provide complete disclosures about their own involvement with the company? And if that's the case, shouldn't this go back to Congress? If there's a need to fix this, why doesn't Congress fix it rather than this court?
Because Congress provided in the Securities Act for broad remedies that should be interpreted flexibly. That's what this court noted in Ernst & Ernst versus Hochfelder, where the court emphasized the purpose of the Securities Act is to protect investors. And the Securities Act does adapt with time, especially Section 17 at Section 12 at subsection A2. In that provision, it states that someone could be found liable for promoting selling a cryptocurrency through a misleading prospectus. Congress defined prospectus in Section 2 at subsection A10, where they stated that a prospectus is a prospectus, as that term is used as a term of art, but it's also a notice, a circular, an advertisement, or any other communication, whether by radio or television.
But doesn't that confirm that Congress was really thinking about something where there's a lot more intentionality than what you see in a social media post like this? You know, it seems to me a prospectus, certainly when Congress enacted this statute, was a piece of paper that you printed up and you handed out to specific people. And so the notion that you intended to solicit them was pretty clear to you. I'm not so convinced that that's true in the social media context.
Your Honor, under Section 12, there is no intent requirement. It's a strict liability statute.
I appreciate that, but whether or not the actor has any appreciation that she might be incurring liability, as Justice Murphy said, might affect our reading of the statute, I would expect.
Ms. Possible does have an affirmative defense available to her. If she had no reason to know that she was giving a misleading statement or didn't know that she was giving a misleading statement, she could assert that affirmative defense once this case gets to that point. Here, we're just at the motion to dismiss phase.
And speaking of the pleadings, doesn't Dr. Draken need to allege that he was targeted by Ms. Possible?
No, Your Honor, he doesn't. That's not.
Why is that?
Specifically because reliance is not an element under Section 12 either. Dr. Draken has alleged that there is a sufficient nexus here because he's alleged that he purchased Octocoin after he did research. That's indicated on page 8 of the record. Page 6 of the record indicates that Octocoin's value rapidly inflated after Ms. Possible posted this promotion. Page 7 indicates, once again, it skyrocketed after she participated in the cage match. Dr. Draken only purchased Octocoin because its value was so high. And it was only so high because of Ms. Possible, taking the facts in the light most favorable to Dr. Draken. Ms. Possible wasn't incidental to this transaction. She was directly involved by encouraging and urging her followers to purchase Octocoin. And she gave material information through that link. The Ninth Circuit.
If someone had taken her post and reposted it to their followers, verbatim, would that person be subject to liability and SEC enforcement?
No, Your Honor, because that person didn't contract with Octocoin to receive that financial benefit. And here Ms. Possible had a financial benefit. The record indicates on page 5 that she was to receive 1,337 Octocoins as part of this solicitation effort. The more people she solicited, the more money she ultimately got. And that's exactly what happened.
Okay, so then turning to the Section 17 issue, why isn't the disclosure of the 1337 coins sufficient? What exactly did she need to disclose?
She needed to disclose two things, Your Honor. First, that receipt of consideration wasn't tied to any outcome in the cage match. And second, that 1,337 octocoins amounted to $1 million at the time of her promotion.
Why that first prong? What does that have to do with the sale of the security?
It's for purposes of the SEC's claim under Section 17 at subsection B. She needed to fully disclose the receipt of consideration and the amount thereof.
No, but why? I think you said, if maybe I misheard, that the outcome of the match was irrelevant to her compensation. Why is that relevant to your theory of the Section 17 violation?
Because it makes it ambiguous whether or not she would receive that money. She stated, as you can see on page 6, that she's earning an octocoin prize in the ring. Her followers could understand that that means that she might not win it if she doesn't win, but she would receive it no matter what. And the dissent points out that she admits she would receive it for both the post and the cage match on page 42 of the record.
But don't cases require simply a disclosure of the compensation to be received? And so I got you on translating the 1337 coins into a dollar amount. We'll decide whether that's required. But why does there need to be a disclosure about the other terms, the reasons why she was being paid the 1337 coins? That doesn't seem to be reflected in the case law, but maybe you can give me a citation.
Your Honor, I see that I'm out of time. May I respond to the question?
You may.
It's not that she needed to disclose the terms of her agreement. It's just that she needed to disclose that she was being paid to post that particular promotion. And it didn't make it clear that she would receive that money for posting that post, regardless of the outcome.
Thank you, counsel. We will now hear from respondent.
May I proceed?
You may, thank you.
Chief Justice, Your Honors, and may it please the Court. My name is Daisy Abarca Espiritu, and I, along with my co-counsel, Mr. Joe Orlando, represent Ms. Kim Possible. I will be arguing the personal jurisdiction issue, and Mr. Orlando will be arguing the sections 12 and 17 issues. Social media has certainly transformed the way that we communicate and the way that we do business. But what has not changed is the Due Process Clause's requirement that a foreign defendant can be subject to personal jurisdiction only when she has sufficient minimum contacts to the forum. The district court lacks personal jurisdiction over Ms. Possible for two reasons. First, Ms. Possible's promotional agreement with Octocoin did not create a substantial connection with the United States. Second, Ms. Possible's Y post was targeted at her millions of international followers generally and not her US followers specifically.
What
I'd like to start.
What about her visit? Yeah, I think maybe you're glossing over the visits that she made to the United States. Could you, and I think she has a P.O. box here as well? Maybe
Yes,
you
Your
want to
Honor.
address those as well.
And that's exactly what I would like to address first, is the fact that petitioner discussed the prior travel to the U.S. as part of her prior work with other brands, and that P.O. box is also a part of work with other brands. Our contention is that that prior work and that prior physical travel, it's not relevant to the analysis today because it's not related to Dr. Draken's claim.
So if we disagree with you on that point and we find it is related, then do you concede that there's personal jurisdiction, or do you still think they have not shown it?
No, Your Honor, they would still not have shown it, even if we just look at the, or even if you disagree and you consider that past work as well as the Octocoin agreement, we would still win. Those together still don't establish minimum contacts.
And why is that?
Well, turning first to that prior promotional work, again, it's unrelated to the claim. It's far too attenuated to count as a basis for specific jurisdiction. In this case, Dr. Draken hasn't alleged that he was harmed generally by Ms. Possible's marketing activities. Instead, he alleges that he was harmed specifically by Ms. Possible's marketing of Octocoin. And so absent any strong contacts related to that marketing of Octocoin, there is no personal jurisdiction. Now turning to the Octocoin contacts, the Octocoin agreement is a contract between Ms. Possible and a US-based corporation. And as petitioner said in Burger King, this court found that contracting with a resident company can sometimes give rise to personal jurisdiction. But in Burger King, this court looked not just at the existence of a contract, but rather the terms underlying the contract. It looks specifically at what kind of activities the parties were contracting for, and importantly, where that activity would be centered. And in this case, we have Ms. Possible contracting with Octacoin to promote a product that isn't centered in any one place. She's promoting cryptocurrency, which is decentralized in nature. And the record at page 4 indicates that Octacoin, in hiring Ms. Possible to do promotional work for them, wanted to enhance this idea that their business was trans-border and decentralized.
Doesn't that kind of prove too much, counsel? I mean, it can't be the case that anything that is online can't give rise to personal jurisdiction, right? I take it you'd agree with that. So how do we take that into account without simply shielding from any jurisdiction and lawsuit anything that's online?
Yes, Your Honor. We do agree that social media can give rise to personal jurisdiction. And in the cases where that would happen, there would have to be express aiming. That's what this court required in Calder versus Jones when there's an allegedly harmful communication coming out of state and harming a resident plaintiff. That communication must be expressly aimed or targeted at that forum. And so the line there would be, is this social media post expressly aimed at the forum? And in this case, it's not. If we look at the words of the social media post, it's plain on its face that she never once mentions US followers. She never once calls out US investors. She does nothing to contain her influence to only American followers.
Am I right that Octacoin actually provided Ms. Possible with the language of that post?
That's right, Your Honor.
Okay, so we've got a contract with a United States company. Ms. Possible was operating under that contract with the United States company. The post that's at the heart of this case was provided to her by that United States company, and nevertheless, there's no jurisdiction in the United States. Help me with that.
Yes, Your Honor, and we hear your concerns about how that company is headquartered in the United States. Importantly, it's important to distinguish the kind of relationship Ms. Possible has here. She's not acting as an agent of the company. She's not involved in any major decisions. Nothing in the record indicates that. In fact, the record states that she's simply a social media influencer who was hired to do limited promotional work. And so yes, Octacoin did draft the words of that post, but Ms. Possible, by agreeing to the contract, she adopted those words as her own. And when she made this post, again, she made no indication that she was aiming only at American investors. And Chief Justice Halligan, you asked opposing counsel about what case may be closest to this one. And of course, there's nothing exactly on point, but the 10th Circuit in 2011 entertained a case called Schrader versus Bittinger. And there, the court also looked for express aiming. There, the defendant was sending out email blasts about a certain ebook that was basically investment for beginners. And the defendant was being sued in Oklahoma. There, the court noted nothing in the post mentioned Oklahoma. So absent those express words, the court looked at the product and said, is this ebook in any way connected to the forum? Specifically connected to the forum. The court found no, and so the court found that there was no jurisdiction. And so here, even if there were no express words in a social media post, jurisdiction could still arise from the nature of the product that a social media influencer is promoting, or perhaps other activities that
I'd like to go back to something you said earlier, which is that she was hired by the company to promote this match and therefore the coin. Are you saying essentially that if a U.S. company sort of hires somebody who's not based in the U.S., they could say anything they want and escape jurisdiction? Is that seem fair in this day and age?
Certainly not, Justice Richter.
So why shouldn't, it's the same question I asked the other side. Maybe we should have a new test for minimum context, not one tied to how often people are actually standing on the ground in the United States. Why shouldn't we adjust to the times?
Well, Your Honor, Calder versus Jones' express aiming requirement still works in the social media age. Importantly, we would also note that social media posts, they can be accessed just about anywhere. And so a ruling from this court that a defendant is subject to jurisdiction anywhere their social media posts might be read, that would certainly push the bounds of due process.
How is the post, the whole focus of or one of the main focuses of the post is the fight match. and the very unique circumstance of the forum being the four-border. But that whole post is telling folks to be interested in the match. The bulk of the match is going to occur in the U.S. So how is that not aimed into the U.S.? Who else is the target of that? If what you're promoting is a match where 3 of the 4 sides are in the U.S., how is that not aiming into the U.S.?
Well, she's targeting at her global followers generally, and the reason for that is because that octacoin or that octagon match, that's a term from that octacoin agreement that we just discussed, whose purpose, again, wasn't to center her promotional work in the US, but rather to emphasize the global nature of the product. And that international match, you're right, Justice Gonzalez, that the match took place partially in the United States. Notably, it was at an international border. The record at page 4 states that they wanted to emphasize the US rivalry with Newland. We would caution against inferring that that necessarily means that we're only focusing on Americans or people from Newland. We know that Miss Possible has a global following, and if we think about, for example, international soccer, if we think about a game between Brazil and Argentina, it's going to be more than just Brazilians and Argentinians coming to that match.
Does the record indicate whether the promotion and the revenue was from in-person attendees, or was it online? I don't know if the record provides any information on that.
No, Your Honor, the record is silent as to the exact amount of revenue collected either from the cage match or from the sale of the octacoins. And so there is nothing that the plaintiff can point us to say that the effect of her post was to create a substantial American investment into this company. And turning back,
considering if we hypothetically accepted your argument that jurisdiction might not lie here, does jurisdiction lie anywhere when an influencer acts? I mean, if we think there's a wrong, who does have jurisdiction?
yes, Your Honor, and with specific jurisdiction, it always turns to the specific claim being brought. There have been cases among the circuits where they have found personal jurisdiction on the basis of social media posts. There's a case out of the Ninth Circuit called Ayla Skin versus Ayla LLC, where there was an Australian defendant who said, we have no ties to the United States, but that Australian defendant had its influencers making Instagram posts with language saying things like hashtag calling USA followers or hashtag Black Friday. The Ninth Circuit found that that kind of express language, that was American-themed language targeted at an American audience, and on the basis of those posts, that the Ninth Circuit exercised jurisdiction.
If we allowed this case to proceed, and it turned out that 9 out of 10 investors, and you could tell this by the IP address, were in fact from the United States, how would that change our analysis? Does the express aiming have to be, what do I think at the moment, or can it be proven in part by what actually happens?
The focus more is on what was intended to happen. That's where purposeful availment comes from. And
so suppose it turned out that was in fact Octocoin's strategy, and she knew that because there had been some conversation about it. I'm just grappling with whether evidence could be adduced if the case proceeded that would show more express aiming than what you're suggesting.
Yes, Your Honor. In terms of Octocoin's purpose, the plaintiff has alleged that there's only 2 material terms in the Octocoin contract, and that's the post and the cage match. And so in order to proceed to jurisdictional discovery, the plaintiff would have to have some colorable basis to say that there's more to that than what they have currently, and there's simply no indication of that. They agree that the theme of this contract, or the focus of this contract, is this Y post and this cage match, and beyond that, there's nothing really that would open the door for them to do jurisdictional discovery. Allowing them to do jurisdictional discovery at this point would simply amount to allowing them to take on a fishing expedition for contacts. And so in this case, the plaintiff has not sufficiently alleged that there are minimum contacts as established by purposeful availment of the forum. And Chief Justice Halligan, I did want to answer your question about what if we found that 9 out of 10 of the American investors were, or 9 out of the 10 investors were American. In that case, if we assume that that was the case, there would still need to be a showing of purposeful availment. It would not be enough that that was the effect that happened. If we think about a case that this court heard in Nicastro, a large amount of that defendant's product ended up in New Jersey, but absent Absent a showing that the defendant had purposely targeted that product at New Jersey, this court found that there was no jurisdiction. And that's the same case here. Thank you, Your Honors.
Thank you, counsel. Whenever you're ready.
Madam Chief Justice, and may it please the court. My name is Joe Orlando. As my co-counsel stated, I'll be addressing the Section 12 and Section 17 issues on behalf of Ms. Kim Possible. This court should hold that Ms. Possible is not liable under the Securities Act of 1933 for two reasons. First, because Ms. Possible is not a seller under Section 12 of that act, she could not have violated Section 12A2. And second, because Ms. Possible's Y-Post fully disclosed the nature of her financial relationship with Octocoin, she did not violate Section 17B. Turning first, Your Honors, to the Section 12 issue, Ms. Possible could not have violated Section 12A2 because she is not a Section 12 seller. Pinter versus Dahl, this court limited Section 12 seller status to those instances in which the defendant has a relationship with the plaintiff purchaser. This court spoke to a very specific type of relationship. In that case, this court was interpreting Section 12's operative phrase, offer or sell, and it rightly recognized that the baseline understanding of that phrase, to offer or sell, is a relationship of contractual privity between the buyer and the seller, wherein title to the item is actually transferred. Now,
Counsel,
of course,
when Matt Damon did commercials for some Bitcoin product that went all over my television set and the television sets of hundreds of millions of Americans, are you saying he wasn't a seller of that security?
that's correct, Your Honor. And to illuminate why, we can look back to this court's holding in Pinter. Now, as we were discussing, this court recognized that the baseline understanding is privity. It did, of course, recognize that Section 12 seller status extends somewhat beyond contractual privity, so Matt Damon doesn't have contractual privity, but Section 12 seller status does encompass some individuals without privity to allow for some measure of solicitation liability. But Justice Murphy, this court still made clear that the relationship which does exist between a Section 12 solicitous seller and a Section 12 plaintiff has to be close enough to that baseline of privity that it would still be fair to say that Section 12's purchase from requirement had been satisfied.
So Damon, yes or no, is a seller?
No, Your Honor, and the reason why is because he doesn't have the type of relationship with anybody who would have purchased that cryptocurrency that would make it fair to say that those individuals actually purchased their security from Matt Damon.
Counsel, here's my concern with that position. To return to a point that I think Justice Richter raised, maybe we need to think a little differently about where that line is. And as you say, you know, Pinter doesn't require privity as an absolute matter, but it seems to me that you know, there are all kinds of products, whether they be Matt Damon or your client, that can be marketed online, and it seems to me that you're suggesting that all of those individuals would be shielded from any liability. So maybe we need to think a little bit more differently about where that nexus is and how to draw the line.
Your Honor, individuals who utilize social media as a means of promoting goods certainly could be held liable under federal securities law, and it is possible that they could solicit the sale of a security using social media.
So why is that not what we have here?
Your Honor, the reason why is because Ms. Possible did not use social media in order to engage in a direct communication with any of her followers. Now, we can envision instances in which that is true. Ms. Possible could have utilized social media to send direct messages to a number of her followers, and that certainly would be a much closer case, and it's quite possible that Ms. Possible would be a Section 12 solicitous seller in that case.
She had said in her post, if it was not a DM, but she had said in her post, go buy your Octocoins now. Hurry up. You know, prices going up. Would that be sufficient, or is it your position that it's the DM that's required? It's the direct connection between the poster and the recipient of the message?
That's correct, Your Honor. Our contention is that only direct communications and direct interactions can serve as the basis of Section 12 solicitation liability.
And does that mean that she needs to know who she is having that conversation with?
Your Honor, she doesn't have to have some sort of a personal relationship or a personal connection to them, but she would have to direct her communication to them. And to be clear, it might not be the case.
How is calling all of my followers to blah, 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 how is that not a direct communication to her followers?
Your Honor, when we talk about direct communications, we're talking about direct communications in contrast to mass communications. And so our contention would be that under any normal understanding of those terms, a social media post that's indiscriminately distributed to all of an individual's 15 million followers qualifies as a mass or an indirect communication as opposed to a direct or a targeted communication.
So let's say that Ms. Possible took the same post and sent it to each of her followers using some automated tool. Then you would concede that there would be liability here. Same message and same followers, but she sends it through direct message to each of her followers. Is there liability there?
Perhaps, Your Honor, and that's because that would be a direct interaction. And to be clear, that's what Congress meant to address.
Counsel, you're asking us to pretend like we don't know what the term follower means. And maybe that the answer is Congress ought to fix this. And if that's your answer, I would understand it. But when you have followers, they follow you. You don't send them individual messages. So essentially, there would be a carte blanche for social media influencers for posting whatever they want under your analysis.
Certainly not, Your Honor. And the reason why is because there are other provisions of federal securities law that are aimed at dealing with those sorts of broadly disseminated promotional communications. Now, one of those provisions is Section 17B. Of course, we'll be arguing in just a few minutes that Ms. Possible didn't violate Section 17B in this case either. But importantly, Your Honors, it's not because she's not the type of defendant or because her communication is not of the sort that falls under the ambit of that provision. It's simply because, as we'll discuss, Ms. Possible satisfied her disclosure requirements in this case. And so there is no carte blanche for social media influencers to post whatever they want, because there are other provisions of securities law that are aimed at dealing with those sorts of indirect interactions.
So putting the direct issue to the side for a moment, on the text of the promotion, do you have an argument there that it does not count as a solicitation because of the language used?
Your Honor, there's nothing in the language that we suggest is the reason why this is not a solicitation, a Section 12 solicitation. The reason why we suggest this is not a Section 12 solicitation is because it's our understanding that when Congress used that term solicitation in defining offer or sale in Section 12, it was referring only to direct interactions between Section 12 plaintiffs and Section 12 defendants. And the reason why we know that, Your Honors, is because where Congress did seek to impose liability for indirect interactions between securities purchasers and other individuals in the Securities Act, it said so explicitly.
But what makes this indirect? Is it, I mean, she is posting it and she is clearly aware that each of her followers is receiving it. There's no intermediary, right? So why is it indirect?
Your Honor, it's indirect because of the mass nature of the communication. Again,
but doesn't that mean that someone who posts something, which may or may not be misleading or may not have adequate disclosure, I know you're going to turn to that shortly, but the more people that receive it, that's why they're not liable? That seems a little counterintuitive to me.
Only under Section 12, Your Honor, and it's because that's what Congress was intending to target when they enacted Section 12, was direct interactions. Where Congress did want to regulate indirect interactions, more attenuated interactions between individuals and securities purchasers, again, it said so explicitly.
So let's say I was at a rally with 15 million people, and over the microphone I say, everyone here should go out and buy Octacoin. Am I a solicitous seller under Section 12?
Under Section 12, you're not, Your Honor. Now, that communication would still be regulated under other provisions like Section 17B or like Rule 10b-5, which generally prohibits material misstatements or omissions that are related to the sale or purchase of a security.
What if there were only 10 people at the rally? It's just a little room, and I tell everyone of the 10 people, go buy Octacoin. What do you think there?
Your Honor, that would be a much closer case, and I think that emphasizes that this is not a close case. Whatever a direct communication is and whatever sort of relationship or directness Pinter requires, certainly it requires something more direct than 1 to 15 million. So This court doesn't have to address that sort of a question in this case. It's sufficient to say that whatever sort of directness Section 12 requires, solicitation liability that is under Section 12 requires, it has to be something more direct than 1 to 15 million. Your Honors, just getting back to those other provisions of federal securities law and other provisions of the Securities Act, again, where Congress did want to impose liability for indirect interactions in securities transactions, it did say so explicitly. Section 2A11 of the Act defines the term underwriter to include all those who participate either directly or indirectly in the sale or purchase of a security. Section 5A similarly imposes liability on all those who participate either directly or indirectly in the sale or delivery of an unregistered security.
So on Section 17, isn't the post misleading because it does not indicate that the coins were being provided to Ms. Possible because of the post and other activity and not as an earning from the match?
Your Honor, if all that Y post had said, and we can look to the record at page 6 where the Y post is reproduced, if all that it had said was, I'll have a chance to earn Octo coins in the ring next week, hashtag promotion, then we would agree that that would be prohibitively misleading because it would suggest to Ms. Possible's followers that she was only being paid for a one-time promotional event in which she was to be taking place. But importantly, Your Honors, that's not all that the Y post says in this case. We can look to the record at page 6 and we see that the Y post begins with a reference to OctoCoin's general slogan to hashtag invest in yourself. It then uses the term promotion, a common use of which is to indicate to an audience that you're being paid for a communication. And most importantly, Your Honors, the Y post ends with a link to OctoCoin's general website where Ms. Possible's followers were given instructions and information as to how to purchase OctoCoin's general and primary product. It's cryptocurrency. And so when the Y post is read in its entirety, its most natural reading is not that it's a one-time promotion.
What case is most supportive of that argument, that if you put all of these pieces together, even if it's not set forth in this disclosure itself, the breadcrumbs lead you there? What would you direct us to?
Your Honor, this is a case of first impression. This court has never interpreted Section 17b, but we would point this court to the most natural reading. This court often, in statutory interpretation context, relies on the most natural reading, and we think where you're interpreting a Y post, you should also rely on the most natural reading. And our contention would be that where Ms. Possible begins her Y post with a general reference to a company, she uses the term promotion, which celebrities often do to indicate that they're being paid for a communication, and then she links to a company's general website and provides information about its primary product. The most natural understanding is that this is a promotional communication that's part of a general promotional agreement, and that
Are we supposed to, how do we know that this hashtag promotion, you said followers know that it means someone's being paid? It's a motion to dismiss. Surely we can't take judicial notice of what hashtag promotion is. So how do we accept what you've just said?
Two responses there, Your Honor. First, again, if promotion was there in a vacuum with the sentence that immediately precedes it, that she'll have a chance to earn Octo coins in the ring, then we would agree that that would be misleading. But promotion, when taken with all of the rest of the terms, our contention is that the most natural understanding of all of those terms is that this is a paid communication. And just very quickly on the 12b6 issue, with respect to the SEC's enforcement action under Section 17b, we are not at a 12b6 stage. The SEC brought this enforcement action in the District of Ragnarok. Ms. Possible appealed it directly to the 14th Circuit, and then this court granted certiorari. And so the facts don't have to be read in the light most favorable to the SEC with respect to the Section 17b enforcement action. Now, Your Honors, I also want to address opposing counsel's argument with respect to Ms. Possible's failure to convert her OctoCoin holdings into a cash value in her disclosure. And this is a point that Judge Rockwaller did raise in dissent below in the 14th Circuit as well.
Before you address that, can I ask you one other specific question? I take it from the record that at least some of this activity occurred when your client was underage. Is that right, under 18?
That's correct, Your Honor. The
and
negotiation...
Does that matter for your argument at all? Should we take that into account, and if so, how?
No, Your Honor. We agree with opposing counsel on that point, that once Ms. Possible reached the age of majority and she failed to void the contract and she in fact accepted its payout, that she is bound by that contract, and that would be the case for both the personal jurisdiction question and for the Section 17b and Section 12a2 question. So that doesn't factor into our analysis. The reason that we believe Ms. Possible is not liable is because she did not violate Section 12A2 and she did not violate Section 17B. Now, getting back to that dollar amount conversion requirement that opposing counsel urged upon this court and that Judge Rockwaller urged in dissent below, Your Honors, that sort of a conversion requirement has no basis in either the text of Section 17B or in its purpose. Beginning with the text, Section 17B requires disclosure of both the receipt of consideration and the amount thereof behind a communication, not the dollar amount thereof. And it's for that reason, Your Honors, that lower courts in other non-cash consideration contexts, and we can look to SEC versus Gorsuch and similar cases, have not required that promoters convert non-cash consideration into cash values. For example, when a promoter receives stock in exchange for a communication, lower courts have not required that they convert those stock payments into a cash value in disclosing.
But isn't that because there's a ready availability of people to determine what a stock is trading for at any given point in time? Suppose I said I'm going to get a quantity of old baseball cards for promoting this product, but I don't tell you how old they were, or whether it was an Honus Wagner $4 million card, or a Mickey Mantle rookie card, or, Joe Slobotnik's worthless card.
Your Honor, as a matter of policy, it may be so that it would be more clear to require a dollar amount conversion requirement. But
isn't that what Bitcoin is like, though? I mean, you don't really know what it's worth at any given point in time?
Your Honor, it is true that cryptocurrencies, and Octocoin in this case, is a new and highly volatile sort of asset. And that speaks to the purpose of Section 17B. And when we consider that, it becomes clear that it makes even less sense to impose that sort of a dollar amount conversion requirement in a case like this. Justice Gonzalez, as you pointed out to opposing counsel, in this case, if Ms. Possible had made her disclosure in a dollar amount, if she had said, I will be receiving 1,337 Octocoins, which are worth $1 million, it's quite likely that the SEC would be before this court arguing the same thing, that that was an insufficient and inaccurate disclosure because at the time that she was paid, Ms. Possible was her Octocoin holdings were worth $2 million, not $1 million. And so when we consider that fact, it does become clear that just like the text of Section 17B, the purpose of Section 17B, which is to provide additional clarity to investors, also is not served by a dollar amount conversion requirement. Thank you, Your Honors.
I believe you've reserved 2 minutes for rebuttal.
May it please the court. Ms. Possible asked this court for an easy way out. Counsel for Ms. Possible first argues that her post on page 6 isn't targeted because the language isn't targeted. Presumably, she would have needed to say, calling all of my United States followers, or all of my followers in Ragnarok. But that would give her an easy way to evade liability. All she would have to do is delete the words United States in Ragnarok, and her post would have the same effect.
Can I just ask you the flip side maybe of that? So with respect to, you made the point about strict liability. And I worry that that plus the breadth of what we are seeing in the social media context creates the opportunity for almost untrammeled liability. Do you want to respond to that?
Yes, Your Honor. We're not arguing that because Ms. Possible's post was accessible everywhere, that she should be subject to suit everywhere. It's just that she made sure here that her post would reach an American audience when she came into the United States to cultivate that audience. Counsel for Ms. Possible argues, for purposes of Section 12 at subsection A2, that Congress meant for those communications to be directly targeted to an individual. But this court assumes Congress meant what it said. And Congress didn't say that those defendants are only liable to people they directly targeted. It says that those defendants are liable for any communication that results in a misleading statement. For purposes of Section 17 at subsection B, counsel argues that this court should interpret Section 17 in the most natural reading. But the SEC's claim is significant because this court isn't reviewing it de novo. This court is deferring to the SEC under Motor Vehicles Association versus State Farm. The court is determining whether or not the SEC's adjudication of sanctions was rational. It doesn't have to be the best alternative. It doesn't even have to be the best interpretation. It just has to be rational, and it was. Thank you.
Counsel, I believe the case is submitted. And it's especially good to be able to join in that round of applause this time. So shall we start out with some feedback on your fabulous performance? I'll just start and then turn it over to all of my colleagues. I just want to say I've heard a number of oral arguments, and all four of you were really excellent. I thought that you were exceptionally well prepared, both in terms of the law and the record. That was evident. I think we threw a lot of questions at you. I'm sure many of them you had anticipated, and maybe some of you had not. And I thought you handled them with a lot of poise. Also, I thought that you were very good at making eye contact and returning to questions that we had asked and concerns that we had. And I really look forward to seeing what all of you do down the road when you start practicing. It'll be exciting. So maybe we should start and go in this direction?
I thought everybody had a terrific manner in terms of your temperament with the court in responding to questions, which I think, is always very important when you're in front of an appellate bench, that you are both respectful and responsive, but then can continue to move in the direction that you want to move. You all were very good at that. So I thought that was just really impressive.
Yeah, I thought you were great. I've seen lawyers also in a lot of arguments call judges by the wrong name, which always is a disaster. So I thought the fact you got all our names down and referred back was really very impressive. And just also, the second the questions began, you stopped, which doesn't always happen. People often talk over judges. So great job all around, very close.
You guys were excellent. It was a pleasure to sit up here and listen to you. I think your demeanor, I know it's nerve-wracking, and in some ways, these sort of exercises, I think you'll probably find to be more nerve-wracking than when you're actually practicing. You guys were amazing. I did not in any one of you sense even the most remote inkling of being nervous, which is just incredibly impressive, and your command of your record and the way you interacted with us was just really, really special. So congratulations, you guys really did an amazing job. Thank you for doing it.
Yeah, I want to echo what my colleague said. I see a lot of lawyers day in and day out, and I gotta say, you are better than a lot of the lawyers that I see in court. And so I know that our profession is in really good hands. You are so good on your feet, so good in responding to questions. And I know that you have folks in the audience who are really proud of you, but I am proud of you. And I'm sure that everyone up here is as well. I mean, you really inspire us. And thank you for all the hard work that you've put in and that your teams have put in. You did a great job.
Yeah, well, there's nothing left to say. I couldn't agree more. Also, I thought you were all really good at coming back to where you needed to be in your arguments, even though a lot of the questions led you into a different direction, but you kept it in and that's very hard to do. But I couldn't agree more. Our pride is equal to the people who are in the audience here cheering you on, and thank you for all the hard work. It was really, really great.
Thank you. All right, should we turn to the moment that I know folks have been waiting for, which are some of the awards? All right, I believe that if I have my marching orders right, we are going to start with the awards for the runner-up Best Brief and Best Brief. Is that right? Excellent, I got a thumbs up, okay. I don't know if I've seen thumbs up as a signal on the court that I sit on, but maybe I'll suggest that we try it. Maybe under the table, I don't know. So these briefs were chosen from among the 24 briefs submitted by all of the teams in these final rounds, which I'm sure reflect a tremendous amount of work. So the runner-up Best Briefs, and it turns out that there was a tie this year, were submitted by Team 16, the University of Iowa College of Law, and Team 10, the University of Illinois College of Law. Congratulations. Come get your award. And the award for Best Brief in this year's competition goes to the University of Memphis School of Law, Team 11. Congratulations to all of you. I'm sure that will stand you in very good skill as you start to practice law. I think somebody else is going to, got it, there you go.
The next award is a crystal obelisk presented by the American College of Trial Lawyers, and it's presented for the runner-up for the best individual oralist. This year, the winner of this prize is Kelsey McLean. Kelsey is from the University of Memphis. And the award for the best individual oralist, also a crystal obelisk presented by the college, goes to Joe Orlando. I can see that the Fordham Rams are here in full force.
Home team advantage, I'm going to hazard a guess.
And now the winner of the National Moot Court Competition and the recipient of the John W. Davis Award, sponsored by the college, is Team 3 from Fordham University.
And I would just close by reiterating that we were tremendously impressed with everyone's performance. This was an extremely difficult call and a close one, and so congratulations to all of you.
The margin of victory was tiny. So congratulations to Memphis as well.
Yes.
Okay.